All right, good morning. People are still filing in, but I wanted to go ahead and get started. Thank you so much for joining us today for Let's Be Blunt, which is, I think, the best title we've ever come up with for a webinar. Thank you to our marketing team for that. We had a fun time with this one, but it's a serious topic for sure. And I know you're all are here to hear what your responsibilities are as an employer and what your employees' responsibilities are in this ever-changing legal space that is state by state changing seemingly by the month. Still the same at the federal level, but changing in locality. So we'll go through all of that today. My guest is Emily Schlaudecker, back from Mineral, formerly Mammoth Think HR. Hi, Emily.
Hey, good morning, everyone.
So when I told Emily that what the topic was for today, she jumped at the chance to come and talk about this. No, actually, Emily is a monthly visitor for us, or every other month she joins us. So this is actually her regular rotation. So we're so glad to have her back. And Emily is joining us from Portland, Oregon. And Emily, do you want to talk really quickly about Mineral and what Mineral is? I know you guys just rebranded, so I just wanted to give you the floor for a couple seconds to introduce what you do.
Yeah, absolutely. Thanks so much. So, Mineral is an HR technology company. So, we offer some different levels of service for primarily small and medium business owners who either would like some help with HR or maybe don't have an internal HR person. So, all the way from, kind of DIY templates, all the way up to one-on-one consulting services. And yeah, I oversee our consultative services program.
Great, thank you. I know I just put you on the spot. I appreciate that.
Of course. Thanks.
So yeah, so we work with Mineral in a variety of ways to support our own HR consulting service in-house, which the trade name is Boost. And then so I direct that department. So we partner with Mineral on a variety of different types of programs, this being one of them. And they're great. And many of you might already be subscribers to their self-service HR support center, which is a really fantastic resource for all sorts of HR related content. So just a little plug there. All right, so a couple things, as you guys all know, we will record this webinar and post it on our website by the end of the day today on our COVID-19 resource page, even though this is not a COVID topic, but that's where our webinars live for now. If you would like to submit a question, you can do so at any time, but we ask that you use the Q&A function and not the chat, and that way we can save those questions for later if you put it in there. So please use that instead of chat. If you don't feel like submitting your question in this format, you can send your question to questions@dominionpayroll.com. And that's something that it triages to me and some other folks on our research team, and we'll get back to you to the best of our ability. Okay. So also caveat, I had a lot of fun with stock imagery for this one. So get ready for some really great photos. So like I said earlier, marijuana is still illegal on a federal level for any purpose, be it adult use or medicinal. It's still listed as a Schedule I controlled substance, meaning it is classified as having a high potential for abuse and no accepted medical use. We don't know, I don't know when or if this will ever change, but this is the current status. But as we all know, despite the federal status, many states in the US have legalized cannabis for medicinal and or adult use. And in 2013, the Justice Department said it would not sue to block laws legalizing cannabis at the state level, as long as states enact regulations that curtail underage sales, interstate trafficking, illegal cartel and gang activity, and excessive cannabis-related accidents and violence. This tenuous trust but verify policy has largely remained in place, with the federal government generally declining to devote resources toward enforcing federal laws in legal states. So that's the current status at the federal level, which makes things a little complicated, and we'll talk about that in a second. Anything to comment on here, Emily, about the federal status?
No, I think that you did a really good job of providing an overview.
Okay. And I apologize, you guys. I have a little bit of a summer cold, so I sound terrible, but bear with me. Okay, so in Virginia, hold on, sorry. In Virginia, as of July 1st, which is rapidly approaching, possession of up to 1 ounce or 28.3 grams of marijuana with no intent to distribute will become legal for adults 21 and older. Adults will be allowed to grow up to 4 marijuana plants per household. Buying and selling will remain illegal until January 1st, 2024. Smoking in public also remains illegal. We are here in Virginia, we are the 13th state to expressly provide employment protections for medical marijuana card holders by prohibiting employers from terminating, disciplining, or otherwise discriminating against an employee, quote, for such employees' lawful use of cannabis oil pursuant to a valid written certification. And we will go into that in a minute, because I know you guys have a lot of questions about that. Adults, again, this is 21 and over, not 18 and over. Adults caught with more than 1 ounce but less than a pound will face a $25 fine. So that's a pretty low fine. Adults caught with more than a pound can be charged with a felony punishable by between 1 and 10 years in prison and a fine of up to $250,000. So hopefully you guys will never have to worry about this, but in the workplace, but the implication there is that if you have more than a pound, you're likely selling it and not just consuming it recreationally. And again, in Virginia, and while sales of the drug are illegal, the legislation permits gifting, which is, I love, up to 1 ounce of the drug to any adult. People under the age of 21 caught with the drug face a $25 fine, but would also be required to enter a substance abuse treatment and education program. So that's kind of an interesting thing too. I'm not sure how that's going to go down yet. Now, I know we have clients in all 50 states. What I focused on today was the states in which we have the most clients. If you have questions about your state status, there are a couple of pretty good websites out there that keep up to date, like sort of tracking maps of the different statuses of each state. And obviously, if your state is about to decriminalize it, you'll probably hear it in the news. But these are the 6 states, in addition to Virginia, where we have the most clients. And as you can see, the southeastern part of the United States is still pretty limited in terms of medicinal or recreational use. If you Google one of those maps, you'll see that the West Coast, the Northeast, and then some states in sort of the Midwest area are the ones that are a bit more progressive in relaxing its marijuana possession rules. So if you have questions about your state, I would do a little research, or you can send me an email at questions@dominionpayroll.com and we can research it for you. Emily, I know I've been talking for a couple slides. Anything to add to this or the previous slides?
Sure. Yeah. So I would say, just to sort of reiterate what you just said, this is a really rapidly changing area of HR compliance and HR regulations. So if you're not sure where your state lands, it is really important to look it up. So, we're going to touch on things really high level today, but there is a lot of variation. So the states that Leslie's showing on the screen right now are all fairly consistent, but to give a couple of examples, Maine, for instance, has a really strict program, not even just for like marijuana management in the workplace, but just drug testing in general. So if you're an employer in Maine, before you conduct even a reasonable suspicion drug test, you have to receive approval of your drug and alcohol policy from the state before you can do that compliantly. And then just to give sort of another example, that with Virginia moving to this sort of like, for now you can possess and you can gift marijuana, DC has a somewhat similar law, and I don't know if they anticipated this or not, but it's sort of led to these sort of like pop-up shops where people are selling t-shirts for $40 and then gifting 1/8 of an ounce of weed with the purchase of a t-shirt or something like that. So there's some really sort of creative situations that come out of these laws, especially when they're brand new. So it's really important to sort of stay on top of them and what it means for your business.
Yeah, I know that's been going on in DC for a couple of years now, and I think
Yeah,
states like Virginia that are now coming online with their own relaxed rules are starting to put measures in place to prevent that sort of those workarounds. Um, but for y'all, for our listeners' perspective, we don't really care where they get it, and that's not the point. And um, we'll go into more detail about what to do in the workplace. But you know, trying to track down how people acquire their marijuana is really not your concern. Wouldn't you agree, Emily? It's like it's just. I mean, you need to know the laws in your state, but how they have it is not really in your purview.
totally. Yeah. So I think that, for employers, a lot of times if you're in a state that doesn't have legal, like recreational use, it isn't necessarily on everyone's radar, but you're exactly right. I mean, it's still something you need to be aware of, that you need to be prepared to address, regardless of how someone, is getting weed. You want to make sure that they are safe in the workplace, and that you have a plan in place for how to address it.
Right. Okay. All right. So now what do we do? If you already have a drug and alcohol policy in place, assuming you have one, you do not have to, it probably does not need to change. It's still illegal at the federal level, and you don't have to allow employees to use it during the workday or be impaired during the workday. In fact, you don't even have to allow them to use it in their free time. More on this in a minute, unless you are in a state that specifically protects recreational or medical use in the employment context. So again, it is tricky and it changes per state. So I don't think a lot of states specifically protect recreational or medical use in the employment context. Um, but you could live in one, so might be worth checking on. But if you have a policy, it probably can just stay the same. If you don't have one, I think now would be a great time to get one written, because you probably should already have it anyway, and now it's even more important. And Emily, is there anything that you've seen from your clients, like that they have been changing their policies in a way that you think is maybe overly cautious or maybe or on point?
No, so kind of like you mentioned briefly, what we're seeing a lot of is, especially if someone's in a state that's actively going through like that decriminalization process, is they worry that they're going to have to change their policy, but after looking into it, they decide to keep it the same, right? So, we're going to talk about this a little bit in a minute, but even if recreational is allowed, you're still able to prohibit somebody from using at work, and especially being high or unsafe at work. So those reasonable suspicion policies actually are the perfect fit. And again, we'll talk a little bit more about this, but it gives you a clear path for when are you going to intervene. And so that works pretty well. So like you said, if somebody doesn't have a policy, we're absolutely telling them like, now is the time, let's just be prepared. But if they have a policy in place that was leaning on reasonable suspicion, in most instances, that's still sort of the best practice.
Right. And a good rule of thumb is that even though marijuana is now becoming more accessible and more legal in a lot of areas, in the workplace, you can still treat it like you would alcohol. Alcohol is legal for people 21 and up. And but that doesn't mean you should tolerate people being intoxicated at work. So it's sort of the same approach, although we understand that the effects that these drugs have on people vary. So, it's one thing to smell alcohol in someone's breath and they're acting, have all the telltale signs, but marijuana use can manifest in different ways. And we'll talk more about this in a second, but this having a reasonable suspicion policy signals to your employees that you're aware of the laws, you're aware of what their rights are, but you're also aware of what your rights are, and you're trying to keep everybody safe and healthy in your workplace. And being under the influence of something may contradict that. So one example of a adjustment you can make to your policy is you could say, we recognize that the state of Virginia has legalized both the medical and recreational use of marijuana. However, it's still a Schedule I drug under the Federal Controlled Substance Act. Use during working hours or use during non-working hours that impairs your ability to function at 100% while on the job is unacceptable and grounds for discipline up to and including termination. So, here it is again, you're recognizing the local status, you're also acknowledging the federal status, and you're putting out there pretty clearly that you still need to come and show up and perform at 100% regardless. Anything else on this one, Emily?
No, I think that's a great overview.
Look at those delicious cookies. For those of you who don't know, there are edibles out there, and these are supposedly some marijuana cookies that look really good. But don't eat them at work. All right, so what about on the job? So with respect to any substance use or abuse, we strongly recommend that employers only get into this issue if you have a reasonable suspicion that an employee is impaired on the job. If you believe an employee is impaired, you could, if your drug policy puts them on notice, send them for drug testing. However, since THC stays in a person's system for weeks or even months, a positive result won't provide you with very valuable information about whether they were partaking on the job. Given that, we suggest in most cases that employers forego testing altogether and discipline based solely on the employee's job performance. Slow or distracted behavior, inappropriate laughter, or inability to focus on the task at hand are all reasons an employee should be talked to, regardless of whether they are stone cold sober or smoked a whole joint at lunch. So Emily, let's unpack this a little bit. Basically what we're saying here, for those of you who don't know, THC lingers. So they could have smoked it 4 weeks ago, and so therefore your test results will be inconclusive. So a better focus would be to focus on the performance. And I realize that there are, what is inappropriate laughter, what's distracted behavior, there are lots of factors that could contribute to that. But we're really looking at the output and someone's output, their performance in terms of their specific role and responsibilities.
Yeah. So, like we were just talking about, you can still rely on reasonable suspicion, again, assuming that you're not in a state that specifically protects like THC use in terms of employment action. But this is another option. And it's basically just sort of one step removed from that. And so it's saying, I don't necessarily care why you're not being productive at work or why we're having these issues. If you are being non-productive, if you are exhibiting unsafe behaviors, we're going to talk to you about those behaviors, right? So if you're horseplaying in the warehouse, if you're just sitting on the floor in the corner laughing, like it doesn't matter if you're high, you're still doing something that is non-productive or would not be considered, acceptable work behavior. So you can safely talk about those behaviors without attempting to diagnose the reason behind it. And, certainly initiate progressive discipline for inappropriate behavior. You could ultimately terminate someone for a pattern of inappropriate behavior. And this totally removes you from a situation of having to talk about potential usage.
And on that note, we have posted on our COVID-19 resource page, I believe right underneath where this webinar will appear, on dominionpayroll.com. We have a sample reasonable suspicion sort of checklist. If you find yourself in this situation, this document sort of gives you some guidelines and an opportunity to document what you're witnessing, and also an opportunity to have a witness sort of sign off on the fact that they also saw this. And I think that's a really good move too. I think if you can, keep the situation in a tight circle of trusted people, need to know people, but having another set of eyes and ears to sort of verify what you're seeing and check any sort of bias that you might have. whether implicit or explicit towards this person, I think is a really smart move. And then this form is a way for you to document, again, the behavior or the underperformance, not necessarily the reason for it.
Yeah, and Leslie, I don't know if you added this later on in slides, so stop me if you did. But when it comes to documenting reasonable suspicion, I think another really important call out is you want to try to stay away from hearsay as well, right? So it's pretty common for employees to say, oh, I saw so and so doing this, or did you know that Justin has a Bob Marley bumper sticker on his car? I'll bet you he smokes weed all the time, or something like that. You want to be really careful. That on its own is, in both of those examples, is not enough to sort of initiate that reasonable suspicion. If you haven't had any reason to suspect that someone has been using or high at work, an employee who is not that person's manager or isn't a manager, sort of alerting you to that is more of just like an FYI. Maybe you can keep a closer eye on things, but we would recommend against sort of initiating a full-on sort of investigation for those sorts of claims.
Yeah, and that goes for anything. I mean, alcohol, someone could see, I could see Emily out and about now that we're allowed to do these things. I could see her out and about at a bar having a perfectly legal beverage. And if I came in the next day and said, hey, I saw Emily out and about drinking a cocktail, it doesn't mean that she's got a substance abuse problem. Now, if her manager notices that she's, seems to be behaving differently, then it's on the manager to do an objective analysis, and using that form can help with that. But to Emily's point, I wouldn't rely on hearsay or any sort of like stereotypical judgments made by other coworkers. The benefit of the doubt is always the best starting place. Okay, so earlier we said that you could enforce a no drugs ever policy. And it really depends on your industry. I mean, if you're in aviation and you have a bunch of pilots, I would consider this to be an option. If you are in a corporate setting where people are at desks all day, I don't know if you necessarily need to go this route. You might have to end up firing perfectly good employees just to comply with your own policy. If, for example, if you have tested somebody upon hire and it comes up with a marijuana hit, again, that could have happened 4 weeks ago. It also could have happened the night before. And if it's legal for them to do it and they're not exhibiting any sort of intoxicated behavior, then all of a sudden, if you have this policy, that person is unhireable, which is, they might have been a really great fit. So it does restrict you a little bit. And I know I have a silly example here of a bong falling out of someone's bag, but now that it's becoming more and more decriminalized or used for medicinal purposes, someone might have something on them that maybe they shouldn't have. And if you see it and you have this no drugs ever policy, that means you have to fire them, and you might not want to fire them. So just consider all of that. The more risk-averse approach is to accommodate off-duty cannabis use absent any undue hardship or direct threat. And again, that means, if their usage is somehow compromising their work performance, that would be a hardship or a direct threat to your business. What else on this, Emily, that I didn't cover here?
I think that's a really good overview.
Okay. Hopefully you won't see a bong falling out of someone's bag. That would be messy. All right, so that's an option for you. And again, it depends. I think you really have to look at the roles and responsibilities of your particular workforce. And if they're a forklift driver, you could, and correct me if I'm wrong, Emily, could they have different rules for different areas of their organization? So maybe they have back office staff who's in they're working at computers all day, and then they have people out in the field who are operating heavy machinery.
Yeah, so you could definitely have different policies based upon legitimate employment classifications. The same is true for things like pre employment drug screening, right? So, not even reasonable suspicion matters, but you could decide, like, I'm going to do pre employment drug tests for anyone working in my warehouse because, it's physical labor, they're operating heavy machinery, but I'm not going to do that for my office staff. So, that's reasonably common. You just want to make sure that that is documented, and that you're also consistent within the confines of that policy. So what you wouldn't want to do is get into a situation where you're just sort of making split second, character assessments and deciding who you're going to send or who you're not going to send. If you say we're always going to do it for the warehouse, everyone that works in the warehouse would be subject to the same level of scrutiny. And the same if you decide, not to drug test for your office staff. You shouldn't be just sort of selecting um, others to do that. I always sort of caution, and this is a question we get a lot, is random drug testing very often doesn't mean what a lot of people think it means. So, it doesn't mean I'm randomly choosing you to go for a drug screen because of, again, I use the example of like a Bob Marley bumper sticker on somebody's car. That actually isn't random. You're using information to make that decision, right? If you're going to do something like random drug testing, which is a whole nother can of worms, it needs to be truly random. And in most cases, you're totally removed from that. That would be sort of administered by a third party. It's usually blind, where employees have, a ID number, and a certain number of numbers are picked each month. So just make sure that you're treading lightly there. And if you are interested in some sort of random testing or a specialized testing policy, definitely make sure that you do your research first.
Yeah, and I think it's worth mentioning that um, in this day and age, so, the sort of stereotypical stoner persona or character is not necessarily the case anymore. I mean, there are a lot of different types of people who use a lot of different types of drugs in different formats. And so, the Bob Marley sticker is an easy, that's a sort of a stereotypical, oh, that person must have a tolerance to have a tolerant personal drug policy, but not necessarily. So it's a different age, and I think benefit of the doubt and not allowing any sort of implicit judgment or bias creep in is the way to go. Okay, so with medical users, this is a different sort of animal, because in many states you now can have a doctor's written note that you need to use that cannabis helps you with some sort of medical condition or disability. So you don't have to tolerate use during work hours, nor do you have to tolerate altered mental states from employees who use marijuana prior to their shift. So that's still the same. Like, just because they have a medical prescription does not mean that they can underperform. The idea is that the cannabis is helping them to to deal with the migraines or the anxiety or whatever it is that would prevent them from performing their job. So that's sort of how, same with over our prescription drugs that help treat a variety of medical issues. The idea is that you have a prescription so that you can live your life comfortably and perform your job comfortably. So it's not, having a card does not mean somebody has carte blanche to just be high at work and not perform. That's not what we're saying at all. Now, if the employee discloses that he or she has a medical marijuana card, and you do drug test that person and it comes back positive, you you should not terminate or discipline the employee solely on the basis of the positive test. And you should be careful to document well all of the other reasons that would support an adverse employment action. Emily, do you want to explain what that bullet means?
Sorry, I I was having a coughing fit there.
Sorry
So
to put you on
yeah.
the spot. You want me to run with it? I can.
No, you're good. I think I'm okay.
Okay.
So yeah, if someone comes to you and says that, they need an accommodation, usually it comes up in a couple of different scenarios. If you are doing pre-employment drug screening, it's fairly common that you'll find out about this after the fact. You'll get the results back, you'll see that somebody had a positive result, and then they'll tell you that they have a medical marijuana card. So if that's the case, we recommend following this standard sort of process of having that drug screen reviewed by a medical review officer, and then determining, can this employee safely do their job? So back to the earlier example, if they have a desk job, you probably can make a reasonable accommodation for them. And the fact that their system, tested positive for THC isn't indicative that they've, were high at work or would come to work high. Um, but if they're a forklift driver, then you could proceed across the conversation of like, is this a reasonable accommodation or not? The same is true if it comes up after you've already hired someone, or if you're not doing pre-employment screening. We recommend just engaging in the full interactive process, the same that you would for any other reasonable accommodation request. So have a conversation with them, provide them with the ADA inquiry form that they can take to a medical provider. You want to try to stay out of a situation where you as the employer are attempting to diagnose what medical condition the employee has and what accommodation would be reasonable. Allow a medical provider to sort of make that decision. And that also provides you with valuable documentation when you do ultimately make a decision of whether or not a reasonable accommodation can be made. But like Leslie had said, allowing someone to come high to work or be in an altered state at work is never going to be a reasonable accommodation. It would more or less just be accommodating use outside of work hours.
Right, exactly. So the most conservative, cautious approach is that if you have an employee who does request an accommodation to use cannabis during work or to work while under the influence, the safest bet is to contact an attorney in your particular state just to make sure that you follow all of the steps that correctly that Emily just outlined. Um, you know, the actual medical documentation itself, like if someone produces a card, you might not have ever seen one before. It might be something that you're not familiar with, and they might be different. And I actually don't know the answer to this. They might be different in all the different states that are allowing them. Um, so that's one consideration. And then when you enter into the ADA process, if you've never done that before, there, like Emily mentioned, there is a medical inquiry form that does engage the physician. And so that adds a level of legitimacy to that directive in terms of a medical use of marijuana. So that's the safest bet if you do find yourself in that situation, or if you have, obviously if you have an in-house HR person or an HR consultant, loop them in as well, just to make sure everybody's on the same page. Okay, so I mentioned earlier that there's a reasonable suspicion checklist on our website in the COVID-19 section. And that checklist basically runs through if there's an incident, you would describe it. There's a sort of a whole fun list of behaviors that you could check off that you've observed from this person. There's an area to make a recommendation. There's an area for witnesses, and then signatures of your signature and the witnesses' signatures. The recommendation piece is the really important part too, and that sort of sums up a lot of what we've been saying about think about if you do drug test somebody and it does come back positive, what will your next action be? What are you prepared to do in terms of discipline, termination, nothing? And is this person, do they have a medical marijuana card? Are there other areas of their performance that have suffered? So you really need to think about the end game here if you do have somebody who sort of checks out on this checklist. And to have that, I mean, I would think just sort of the same thing with like back a couple months ago, we were talking about COVID-19 vaccination policies. Go ahead, and you may not ever have to use this suspicion checklist, but go ahead and get together with your leadership and figure out a what if policy and the scenarios, different scenarios, and how you would manage them. Anything else to add on this one, Emily?
Yeah, so just to double back to the reasonable suspicion checklist, one thing we also recommend to clients is look for sort of a balance of different signs and symptoms. So, again, a question we get pretty often is like, an employee came into work with bloodshot eyes. That means they're high, right? And the answer is no. There are a lot of reasons that that could have happened. They could have allergies. They could have had a rough morning and cried before work. And, that's a really simple example, but that on its own probably isn't enough, again, to sort of trigger, let's talk about reasonable suspicion. But if they have bloodshot eyes and they're tripping up the stairs every time they walk in and out of the building, and they're slurring their speech, that sort of highlights different, right, different motor skills, different parts of the body. That whole story is probably enough to start heading down this reasonable suspicion path. But you want to make sure not to, under or over estimate that. And in the situation where you have sort of an odd situation with someone, looking different than normal, that doesn't mean you can still keep an eye on things, but maybe the first time that you witness that isn't the time that you want to jump to this reasonable suspicion process.
Oops, sorry, my phone is ringing. Decline. All right. Yeah, that's a really good point. There are a variety of reasons why somebody might look a little off. Okay. So what about drug testing? I know we've talked about this in a little bit before, but I wanted to dive in a little bit more because we do get this question a lot. And in the broader view, a lot of my clients are moving away from pre-employment drug testing, and particularly, and also random drug testing. But again, it really depends on your industry. So we're not suggesting that you not drug test, particularly if you're in an industry where, again, people are operating heavy machinery or other really safety high risk jobs. But if you do drug tests, if what we're saying here is that if a workplace wants to allow quote unquote passes on a marijuana test for employees with a medical marijuana recommendation, the employer has two options. You can remove marijuana from the panel of drugs to be tested for, or you may continue testing for marijuana, and then in the case of a positive marijuana result, follow the actions declared in your policy for responding to an employee's claim that his or her marijuana use is medically authorized. Either way, employers should have policies in place pertaining to medical marijuana cardholders, which may be similar to those for employees who may require reasonable accommodation for unrelated reasons, such as religion or disability. In such a policy, employers should clearly instruct employees how to engage in an interactive process to determine what reasonable accommodation, if any, can be made with regard to an employee's off-site marijuana use. Employers should then consistently follow the established procedures. As always, you should consult with skilled legal counsel prior to taking any adverse actions, especially in situations where an employee may have medical authorization. So now, Emily, my question is on this. What about people who don't have a medical marijuana accommodation, or medical marijuana prescription, and they do a drug test and there's a hit for marijuana use? And we talked about this a little bit earlier, but I guess you can decide, or I think you should go ahead and decide now what you should do in that case, given that your state's laws at the moment.
Yeah, absolutely. So I would say, this is why it's a good idea to have a drug and alcohol policy and procedure in place so that you know how you're going to react, but also so you're informed on your state's laws. So if you're in a state, which is most of them, that doesn't, protect employees just carte blanche from negative employment action related to illegal off-duty conduct related to marijuana use, you have a lot of freedom. So, if you're in one of those states that were highlighted earlier, you're not required to make any sort of accommodation for recreational use. So that could mean pre-employment drug screen or any drug screen that is positive, again, assuming that you go through sort of that medical review process and make sure that it's a legitimate positive. You could move immediately to termination, but you'd want to be consistent. So, like Leslie mentioned, you could lose someone good in the process of that. The other option would be to offer some sort of like second chance or two strike rule. But you would want to, again, be consistent, and you should have that process outlined in your policy.
Yeah, that's a really good point. Consistency is key. If you're to treat one person one way, you have to treat everybody like that. Unless they have an accommodation, and that's something that presumably you'll go through a formal process to decide how that person will be accommodated for their needs. All right, those are all the slides I have. We could probably talk about this for hours. It's a really interesting topic. And as we mentioned at the top, it's evolving rapidly across the country. So even if you live in a state that is not quite there yet, I would go ahead and consider it to be inevitable at some point. It might not be tomorrow, it might not be next year, it could be the next 5 years, but just go ahead and start thinking about how your company wants to manage this sort of newer world. I don't see any questions in the queue. This is a quiet group today. No questions at all. I suspect as we move into, particularly in Virginia, as we move into the post July 1st world, we'll probably have some questions at that point as things, unique situations arise. Anything else, Emily, that you've seen with your clients or want to mention to this group while we still have them?
No, I think I hinted on some of the major questions that we get. And yeah, just to wrap up and say what you said, I think it's perfect timing to put a policy in place. You don't need to wait for recreational marijuana in your state to be legal. You still need to have a plan in place. So if it's not something that you currently have, it's something that definitely makes sense to start that process.
Excellent. Thank you so much for joining me today. I know this is, I know you're busy, and we always appreciate your time and your perspective.
Of course, always happy to be here.
Excellent. All right, listeners, last chance for questions. And of course, we're always here at questions@dominionpayroll.com. And we'll do our very best to answer it to the best of our ability. And we will see you for another HR Matters in 2 weeks. Thanks so much. Have a great day. Bye, Emily.
Bye.